and Mr. Tabori and Mr. Yarrow appear for the Secretary of State. May I start with some housekeeping?
Yes.
You should have substitute skeleton arguments from each of the parties.
Yes.
And then there is a core bundle of 131 pages, a small agreed supplementary bundle which comprises a single report and has 52 pages, an agreed authorities bundle, 405 pages, and then an agreed supplementary authorities bundle from yesterday of 174 pages.
Thank you.
And there is an outstanding application relating to what the parties have termed the third argument advanced by the appellant in our substitute skeleton argument. And we, as a precaution, sought permission, if that is necessary, to amend our grounds and to rely upon that point.
Yes.
But very pragmatically, we've been told this morning that the Secretary of State does not oppose any part of that application.
Good. Well, that's helpful, thank you. And we see that there's been a degree of recasting and focusing of the argument in a way that's also helpful. I think probably it would be a good idea if maybe now you were just to make sure that your colours are pinned to the mast that you want to pin them to. We think that you're pursuing your ground 2 as originally framed, but doing so in a way that's explained in the substitute skeleton argument. So I know that grounds 3 and 4 have fallen away.
Yes.
And I think that ground 1 has probably also fallen away, has it, and that you're happy with that?
Yes.
And so really we're concerned with opening the box of ground 2 and seeing what's inside that. And I think it would be helpful, before you develop your argument, if you were to tell us the extent to which you and Mr. Tabori and Mr. Yarrow agree about what is in ground 2. He thinks there are 3 things, and it would help us to know. I think you think there are 3 things.
Yes, my lord. We're going on the supplementary skeleton and working from
Well,
that.
What's happened here is obviously that there's been a certain amount of recasting, which we're very happy to work with. But just to make sure before we start that there's a meeting of minds as to what the exact propositions are and the answers to those propositions. So in your own way, but could we make sure that we grasp what the proposition is and what the counter proposition is, and then we can decide which we like.
My lord, first I'm going to refer to what the grounds drafted by previous counsel say, and then I will explain how we recast them, and we entirely accept that we have recast them to a substantial degree. Ground 1 was failure to consider material matters, application of wrong case law. That has fallen away, save that I would point out it's one of the places where previous counsel has, in essence, made a complaint about application of wrong threshold, which relates to what we call argument 3.
So by putting that to one side, you're not conceding that point, but it doesn't need to be made because it appears under argument 3.
Yes. Ground 2 is where counsel has said that the Upper Tribunal judge made a material misdirection in law. Now, it's one of the respects in which we have recast this is that the focus obviously needs to be on the first tier tribunal, not on the Upper Tribunal. And I think that part of the difficulty in the original grounds is that counsel has really focused upon the Upper Tribunal. The key for us is paragraph 8, as concerns a third argument, where counsel said the Upper Tribunal judge has erred in his assessment of the appropriate threshold of what amounts to persecution. And that's really where we say our argument 3 is rooted, although we say actually the problem is principally in what the first tier tribunal does, which the Upper Tribunal then fails to rectify. I'm sorry, and I'm actually using the paragraphs here from the original grounds, so which is the grounds upon which permission was granted, just for simplicity. So they start at page 61 of the core bundle. So paragraph 8 was the paragraph I just referred to. The other key paragraph is paragraph 11. And we do put things differently. Paragraph 11A says that a failure to look at events cumulatively, we agree, but then there's a suggestion that you take the past beating and the future beating and you take those together. Now, we don't put it in the same way. And I will explain in a moment how we do put it. 11B, this is page 63 of the core bundle, then emphasises aspects of the findings as to past events that the grounds say were not taken into account when looking at future risk. And the focus there is upon the blacklist, which is said it would lead to further adverse harm in the future. And we certainly do maintain that, although we say it's not limited to the blacklist. There are other aspects of the past findings that seem to have fallen out of focus when the first-tier tribunal judge was looking at future risk. Paragraph 11C then complains there was no assessment of the severity or degree of harm that a second beating will entail, nor the effect that it would have on this particular appellant in their particular circumstances. And that we again maintain, although we would say it's not just that issue, it's also a failure to look at context. What's the purpose of the beating? Where will he be beating? Will he be in custody? But we certainly do pursue what is said at 11C. Ground 3 then for completeness is put us a complaint about procedural unfairness. We don't pursue that, but the only thing I would flag again is this is again a place where the threshold of persecution is raised. And then at paragraph 14, when explaining the second appeals test, why the second appeals test is said to be met, at 14A, there is again focus on the threshold of persecution. May I take things in this order now? Because I'm very conscious of my Lord's request that I clarify what it is that we say, having taken you through the grounds. But could I briefly summarise the factual background, very briefly, then summarise our submissions, because I think it anchors the submissions to show quickly what the factual background is.
I think, Mr. Pinsky, what we want is the reassurance that we're all discussing the 3 points that are in the revised skeleton argument, and the battleground for us to appraise is those 3 arguments, which you'll no doubt come to in your own way and in due course. But just having that front and centre now will be very reassuring.
It will absolutely be front and centre a few moments from now, if I may. So what I propose to do is give a very brief factual background, then foreground those 3 points, and then take you to what we say some essential legal context, and then show why we say that the relevant legal principles were not adhered to.
I mean, we don't want to be impatient. We can wait for a certain time, but I think we are keen, as this has been an appeal that was allowed to go ahead on certain grounds and is now in effect being argued on refined grounds, that we know exactly what it is that your propositions are. So I'm going to ask you if you would, at this stage, without committing yourself, but just for our assistance when we're considering the facts and the legal context. I mean, I understand your first and main legal point to be that the first-tier tribunal erred in its assessment of what amounts to persecution.
Yes, although, my Lord, I'll take it in the order that we've got it in our skeleton. So, and it's first, second, and third argument. So
very well, put it the other way around.
So first, and this is directly raised, albeit perhaps not as clearly as it should have been in the grounds. The first point we say is that the first-tier tribunal failed to make essential findings of fact in relation to future risk. Right. That can also be recast as a reasons argument, and the respondent very properly has said in their skeleton, well, actually, we think the real question is whether the English and Emery-Reinbold test is met. So the parties do meet there.
Right.
We have said findings. We're happy also to put it as reasons. Is as to future risk.
Yeah.
Has the judge identified the key issues and given clear explanations for the conclusions that he reached upon them? That's argument one. Mm-hmm. Argument two is that the first tier tribunal erroneously confined its assessment of the gravity of what had happened in the past to the single beating.
Right.
And that, we say, rendered the first tier tribunal's assessment of future risk unsafe. And there again, the respondent's answer is essentially not so. The first tier tribunal has done an adequate job.
Right.
The third point, which is where my lord was taking us, is that we say that the first tier tribunal applied an incorrect threshold test when assessing the question of whether the appellant's past treatment had been and future treatment would be persecutory. So this is where the first tier tribunal refers at paragraph 36 to its determination to persistent or systematic. And the respondent's answer in brief is that's the right test, or that is one of the right tests. I think to be fair, I think it is said there's nothing wrong with that test. Look, it's the language appears in some judgments, and we will say in fact it's not being posed as a test. Yes. It's been misunderstood.
Well, it strikes me that the first two arguments are alleged errors of law arising from the tribunal's fact-finding process, and the third one is an alleged error of law in relation to the tribunal's legal self-direction as to what persecution means. Is that a fair way of looking at that?
I would say it's not just fact-finding, it is also reasoning. So
yes, well, I'm very happy with fact-finding and reasoning, but
yes.
There's in a sense, if we're just getting our thoughts in order, grounds 1 and 2 are two different aspects of a particular type of challenge, whereas ground 3 is a different sort of challenge.
Yes.
And they all put together, you say, make the FTT decision wrong in law and consequently the UT decision wrong to have let it pass.
Yes.
Thank you. Well, now, we can now, I hope, get out of your path and you can develop the matter in the way that you would like.
I'm very grateful to the court for highlighting those concerns. Just going back then to the factual background quickly, and then I shall move on to legal background. I'm going to very briefly summarise the factual background now without taking you to the core bundle and the first tier tribunal determination, but I will read out some paragraph numbers so you have them. I'm going to come back just to reassure the court and look in detail at the first tier tribunal itself. So the appellant is a Vietnamese national whose account of past events was accepted by the first tier tribunal without exception. He's a Catholic who attended an illegal demonstration in Ho Chi Minh City in Vietnam concerning the Chinese occupation of the Spratly and Paracel archipelago, and also the seizure by the Vietnamese state of church lands. That's paragraph 8 of the determination. He was fingerprinted, beaten, arrested, and formally charged in connection with that illegal demonstration. Paragraphs 21 to 22 and 32 of a determination. He was also questioned, and in order to protect his friends, he had gone along with 2 friends to a larger demonstration, told the Vietnamese authorities that he was the leader of that small group of friends, paragraph 21 to 22. He was told he was now being placed on a blacklist. This is paragraphs 21, 32 and 36, but he was released. He was allowed to return to his home area, but told that he would be arrested in the near future, paragraph 23. The authorities placed the appellant under surveillance, paragraph 32, and visited his home, paragraph 23. He left the country, as he believed, for his safety, but was in fact trafficked from Vietnam, where the first tier tribunal actually said he spent 4 years in captivity. That's not completely right. It was more like 3.5 years. I'll take you to the exact dates shortly. So he spent 3.5 years in captivity working without payment. This relates to paragraph 34 of the first tier tribunal's determination, before he escaped his traffickers. And by a determination dated the 20th of June 2024, the first tier tribunal accepted that the appellant had given a truthful account of his history, that's paragraphs 28 and 30 to 33, but found that his past treatment did not amount to persecution, saying, this is paragraph 36, I am not satisfied that the single beating was sufficiently serious. As to future risk, the first tier tribunal accepted, same paragraph 36, the authorities may question him on return, and they might slap him or beat him again, but considered the authorities would take no further interest in the appellant, and went on, although a further beating will be unpleasant, I am not satisfied that the conduct will be persistent or systematic. The first tier tribunal also did not accept that there was a real risk that the appellant would be re-trafficked if returned to Vietnam. And then on the 17th of December 24, the Upper Tribunal held that there was no error of law in the first tier tribunal's determination. And I should say that the risk of re-trafficking element of the appeal was not pursued beyond the Upper Tribunal.
Yeah.
And to complete the factual background, I should also add that before the refusal by the respondent of the appellant's protection claims, the appellant already had a conclusive grounds decision in his favour, accepting that he was a victim of trafficking. And the period that's accepted is June 2014 until December 2017. And he consequently received a 1-year period of leave, which has long since expired. So I shall now, if I may, at one point I should also, before I turn to the legal background, I should also flag, of course, Lady Justice Lane, in granting permission, which is core bundle page 46, with respect rightly noted the failure of the tribunals to address Article 3 when considering the appellant's appeal against the refusal by the respondent of the protection claim here. And you might think that the failure may be indicative of a regrettable lack of care, but it is not material for our purposes. And the reason for that is that, as concerned risk, the Refugee Convention reason that's relevant for our purposes, actual or imputed political opinion, has not been in doubt in either tribunal. Rather, the issue is the severity of the treatment to which the appellant has in the past been subjected and would in future be subjected, as to which Article 3 sets no lower threshold.
I was going to say that the standard, if you want to use that word,
It's the same for both.
is the same for both. So,
Well, my lord, if I mean, for physical violence, yes, but of
Yes.
course there may be many instances, one thinks about HJ Iran, where the Refugee Convention will offer greater protection.
yeah, but that's not to do with the treatment on return. That's to do with the identification of a convention reason and how that plays out.
Well,
I mean, there's no doubt in HJ Iran that upon return, because of the appellant's sexual orientation, that there would be big problems.
yes, perhaps HJ Iran may not be the best example. If I can put it another way, you could have discrimination where a whole persistent, to use the first tier tribunal's word, course of discrimination might amount to Refugee Convention persecution, but would not reach Article 3. That's why I'm saying that the two are not coextensive, but
in this case, they are.
When it actually comes to physical maltreatment, they are the same,
yes,
which is really what we're dealing with here.
Yes.
yes, provided one can show the convention reason. Yes. but the Refugee Convention might offer more in that one might have a course of treatment, a course of measures, for example, discrimination plus a beating, which taken cumulatively would add up to persecution, but which might not cross the Article 3 threshold. So that's why I'm a little bit reluctant to say that they are.
No, I'm only
coextensive.
concerned with this case,
Yes.
Yes. Which was where you started. And
Yes.
I hope we are agreed that in this case, it does not make a difference
Yes.
whether the appellant ran the case under human rights or whether he ran it under the convention.
Yes. Yes. Right, my lord. I beg your pardon if I'm
No,
engaging in pedantry.
No, you're not engaging in pedantry. You're demonstrating your encyclopedic knowledge of this area of the law.
It's too kind. So I'll turn now to key legislation and jurisprudence which define persecution for Refugee Convention purposes. And there are 6 short propositions of principle which we derive from the legislation and jurisprudence that I'm about to show you, and which we trust should be uncontentious. And I mention these as context for the submissions that follow. The first point is that persecution can result from a single sufficiently severe act or from the cumulative effect of a series of acts which taken together are sufficiently severe. Second point, the question of sufficient severity has both objective and subjective components. That is, one looks at both the intrinsic severity of the act or acts and their impact upon the particular individual. Third point, both EU and domestic legislation adopt human rights as the benchmark by which the seriousness of ill treatment and whether it amounts to persecution is measured. The fourth point, and this is really perhaps an answer to my Lord Justice Dove's question, degrading treatment, contrary to Article 3, is sufficient but not necessary to constitute persecution. Fifth point, our highest domestic courts have adopted as valuable the formulation of the eminent professor of refugee law, Professor Hathaway, now Professor Hathaway KC, namely the sustained or systemic failure of state protection in relation to one of the core entitlements which has been recognised by the international community. And I'll show you shortly various judgments in which that is cited with approval. Sixth point, past persecution or past serious harm, or even the direct threat of these, constitutes a serious indication that the individual's fear as to future harm is well founded, absent good reasons to the contrary. So, of course, there might be situations where country conditions have changed. And with that, Kelly, can I ask you please to turn up the supplementary authorities?
Out of interest, why is point 5 not point 1?
Let me go back to point 5, I beg your pardon.
Surrogate protection.
I was actually really thinking about the way in which our arguments are going to be ordered. So it was really
Yes,
thinking.
I know, but I mean,
yes.
Coming
Yes.
to this unburdened by your knowledge, I appreciate that a lot of things have been said about protection, but persecution. But we have to say something about it that's meant to be helpful and useful for this case and for other cases. I can quite see that in varying degrees, a lot of your points will have arisen in other cases.
Yes.
may arise in other future cases, but may not arise in other future cases. But surely persecution is something that is capable, perhaps in terms of point 5, I haven't looked closely into it with you yet, being described or explained, so that one simply doesn't fall back on a dictionary. And understand, but it seems to me that of the points that you've made, point 5, which is the Hathaway definition, might in a sense have been at the head of the list that you've created. Because the one thing that I'm sure we don't want to be doing is weighing down tribunals with lots of propositions, as if that gave them a route map in order to make some mechanical decision about this. But in the end, surely what's needed is for a tribunal to understand what is intended by prosecution in its legal sense, and then to apply it to what it finds. So I'm quite sure that we're probably not going to end up having 6 propositions of law in order to achieve that. So going back to my intervention, is point 5, in a sense, your key proposition here? And you're then going to go on to explain why the other ones are applicable in this particular case.
So certainly we would say that the correct definition is that supplied by Professor Hathaway, and also, which I'm about to show you, Article 9 of the Qualification Directive, which is reflected both now in domestic primary legislation and also in regulations which, because of savings provisions, continue to apply to this particular appellant.
Yes, but in the end, you're going to extract for us, no doubt, what you say persecution is to be treated as importing.
Yes.
And speaking for myself, that's going to be the important point here, because there may be other forms, other ways in which persecution can be put, which fall outside the other 5 points that you've raised. It would seem that persecution ought to be regarded as something which is possible to be achieved in relation to the evidence that a tribunal has, without it having to have a large number of, I mean, this is a downhill, it's not a slalom.
My lord, I absolutely appreciate that, and I apologise. I can see that I should have reordered matters.
No, it's not a cause for, but it's because I'm uniquely well placed in the court to ask these questions, because the other members know the answers. But so far as I'm concerned, point 5 would seem to be in a sense, the core, and then you can then develop it. But if that's wrong, you can explain why.
Point 5 is the core, taken together with the legislation that I'm about to show you, which we say provides a very valuable guide and, in fact, a binding guide as concerns both the appellant's case and now currently people who are to whom Section 31 of the Nationality, Borders and Asylum Act 22 applies. But I'll show you that in a moment. So,
which is not this appellant.
Not this appellant. No. But we do say it is a point certainly worthy of note that this is now enshrined in primary legislation.
Yeah.
So this is not of historical interest. So if you could turn up, please, the supplementary authorities bundle at tab 1, page 2 onwards. You'll see the Refugee or Person in Need of International Protection Qualification Regulations 2006. Those are the regulations by which, in part, Article 9 of the by which Article 9 of the Qualification Directive was transposed. And these, because of savings provisions, to which I won't take you unless I'm asked, but they're at tab 2, because of savings provisions, the asylum claim having been made before June 22, these regulations continue to apply to this appellant. And if you could look, please, at Regulation 5 in particular, and page 5, you'll see and with apologies for repetition, persecution can consist of a single act which is sufficiently serious by its nature, or multiple acts which are sufficiently serious by their repetition, so as to constitute a serious violation of a basic human right. Or, and this is 5.1b, and my lord, I completely appreciate that I'm going down into a nitty-gritty here, but these are actually points which it will be seen do matter in considerable degree to this appellant. Or persecution can consist of an accumulation of various measures which can but need not include a violation of a human right. That's why I'm saying it's not completely coextensive. And whose combined effect is sufficiently severe. And then you'll see at Regulation 5.2a, these are non-exhaustive examples of what may constitute persecution. You'll see an act of physical or mental violence, reinforcing the point that I shall make later, if that were needed, but a single act of violence, even violence to the psyche, may amount to persecution. And could I ask you please to turn up the judgment of the Grand Chamber in this same bundle at tab 7. This is Y and Z. It starts at page 81.
I'm just still looking at
Yes.
5.2.
Yes.
So those examples, which are but examples, but would nevertheless seem to give an insight into what Parliament was thinking about when it was thinking about persecution, the sorts of things.
Yes, well, and I should say this is actually this is verbatim reproducing Article 9 of the Qualification Directive, an EU directive. But then you will see, as I shall show you in a moment, that Parliament has taken this same language for cases where the asylum claim is made after the 28th of June 22 and put this into primary legislation. So it cannot be in dispute that this was at the time of the appellant's claim and appeal and remains and will be for future asylum claims.
So that
anything
anything that we say about this is not just relevant to old claims. It would be equally relevant to current claims.
Precisely. And I turn now to tab 7, which is the Grand Chamber of the Court of Justice of the European Union, their judgment in Y and Z. And could I ask you to look, please, at page 112. This is Supplementary Authorities 112, sidelined passages. And could I ask you to read to yourselves, please, paragraphs 65 to 67. So paragraph 65 confirms that the question of severity is measured by both objective and subjective standards. Paragraph 66, like the language of Regulation 5 itself, confirms the need to assess the impact upon the person it concerned, and also shows, lest it were needed, that, of course, the threshold for past and future persecution is the same. Paragraph 67 confirms, and this is, I think, the point that was put to me both by Lord Justice Dove and Lady Justice May, that degrading treatment suffices. So a genuine risk of being subject to degrading treatment suffices to constitute persecution. And I said I would show you that this is not of pure historical interest. In the main authorities, I'll just flag very quickly that at tab 1, you have the primary legislation that now applies, and this is pages 8 to 9 of the main authorities, section 31. So this is exactly the same language reproduced now in primary legislation. So this is the definition applicable to this case, still applied throughout the common European asylum system and adopted in primary legislation. And we do say it's one of the various troubling features of the first-tier tribunal's determination, though we certainly don't raise a fresh ground on that issue, but there's no reference anywhere to any of these definitions. And still on the subject of the effects of the qualification directive, could I ask you please to turn back to supplementary authorities bundle at tab 8?
Could I just mention, it doesn't matter now, but the electronic bundles, some of these electronic bundles that have been filed locked, which prevents them being annotated. It doesn't matter for the moment at all. I can perfectly well manage, but just for future reference, it's useful to file unlocked bundles.
I'm so sorry.
Not at all. No apology required.
Yes.
I hadn't realised that this one was also locked. I was getting.
It may be that at the lunch break we can send the clerks unlocked versions directly.
We may not be here after lunch. Don't worry.
Yes.
Thank you very much. So right, we're on this, and you're about to show us that this has all been carried through under 31 into the current legislation.
Yes, and so I didn't intend to spend any time on that, but it was just to show you where it is. Tab 1, main authorities, page 8. Although none of this may be of much assistance.
They're correct.
Bundles are locked.
Thank you.
And then where I wanted to take you next, please, is another aspect of the qualification directive. Could I ask you to turn up, please, in the supplementary authorities at tab 8, the Grand Chamber judgment now of the European Court of Human Rights in JK and Sweden.
I'm sort of assuming that although the FTT is supposed to know every case that was ever decided, that these cases were not in fact referred to.
I don't believe they were, my lord, but
troubling it may be, but it's not troubling because they ignored something that they were directed to.
Well, my lord, the cases weren't, but they certainly should know, as I think I may have interrupted my Lord Justice Dove, they certainly should know the applicable regulations, the qualification directive, that they are 100% required to know.
Right, JK and Sweden.
So, JK and Sweden, the parties each refer to this for different points, but for our part, could I show you paragraphs 99 to 102, and may I ask you to read those to yourselves?
Could I have a page number, please?
I'm so sorry. It starts at 154 and finishes at the top of 156 of the supplementary authorities.
Thank you.
Paragraphs 99
to 102.
Thank you.
And in particular, could I draw your attention to the excerpt at paragraph 100?
Thank you. Thank you.
So this is, of course, an Article 3 judgment, but the Grand Chamber cites at paragraph 100 Article 4.4 of the Qualification Directive. And what I wanted to highlight in particular is that that refers not only to past persecution or serious harm, but also direct threats of such persecution or such harm. And then the other point I wanted to highlight is at paragraph 102, that the position of the Grand Chamber is that once the fact of past ill treatment is established, it's for the expelling state to dispel doubts as to the real risk of future serious harm. And for the court's reference, for some reason, different parts of a qualification directive were differently transposed. So this didn't end up in the regulations, but it did end up in the immigration rules, which are guidance given by the Secretary of State to her caseworkers, but which have the imprimatur of parliamentary approval. And they are found still at 339K. So 339K of the immigration rules reproduces Article 4.4 of the qualification directive. So it must be common ground that this is an accurate statement of how the Refugee Convention must be interpreted. This is still in the guidance that the Secretary of State gives her own caseworkers. Could I ask you now, please, to turn up the case that we mentioned earlier, which is HJ Iran, Authorities Tab 7. It starts at page 83, the judgment starts at page 105. And this was the case where the Supreme Court held that where a gay person would, in the event of being returned, conceal their sexuality, at least in part owing to a well-founded fear of persecution in the event of their sexuality becoming known, then the person is a refugee, even if the concealment would be successful in that they would never, in fact, have their sexuality come to light.
Could I have a page number?
I'm so sorry. Could I ask you to turn to page 108?
Thank
So
you.
this is paragraphs 12 to 13 of Lord Hope's judgment. And we can see here that Lord Hope's cites the earlier case of Sepet and Bulbul, where, and this is paragraph 12 to 13 that I'm referring to. And in Sepet and Bulbul, Lord Bingham had observed the strength of the word persecution, and I'm going to return to that point. Lord Hope then cites the Australian High Court case S395, noting the range of forms of harm which persecution covers, from physical harm to the loss of intangibles, from death and torture to state-sponsored or condoned discrimination in social life or employment. And then at paragraph...
That quote continues.
Yes, my lord, the reason why I haven't referred to reasonable toleration is that, as one can see from the rest of H.J. Iran, that sentences tend to be misunderstood. And I wanted to avoid going into a lengthy explanation of that. But we certainly say, of course, a beating cannot be reasonably tolerated. But what's made clear in the rest of the judgment of H.J. Iran is that that should not be taken as the touchstone. So that was why I had stopped short of that sentence, because it has proved so problematic in the jurisprudence. At paragraph 13, we see that Lord Hope cites with approval the formulation from Professor Hathaway, defining persecution as the sustained or systemic failure of state protection in relation to one of the core entitlements which has been recognised by the international community. And then, this is returning to my Lord Justice Jackson's point, we see the reference to the Refugee Convention as providing surrogate protection, which is activated by the failure of state protection. If you turn on then, please, to paragraph 88 at page 136, you see that Lord Walker refers to the findings as to what has happened in the past being always relevant, often crucial. That's paragraph 88. And then if you turn, please, to paragraph 113 at page 144, you see that Lord Dyson notes the utility of a human rights analysis, notes the broad humanitarian objective of the Refugee Convention, the centrality of the right to dignity in the Convention, and then he cites the Canada and Ward case, in which the Canadian Supreme Court in turn cited with approval Professor Hathaway's formulation, sustained or systemic denial of core human rights. Could I ask you now, please, to turn in the main authorities to tab 8, and this is, judgment starts at page 149. This is the case of MI Pakistan. And
Page number.
I'm sorry, it starts
The
at
trouble is
page
because
149.
it's locked, there are no tabs. So I need page numbers. Thank you.
I'm so sorry. Page 149 is where the judgment starts.
Thank you.
We're going to try and resend them if we can as we go, because
It is much easier for a variety of reasons. I'm sure I'm preaching to the choir.
I'm very sorry, yeah. Page 149, and just brief factual context here. MI is a Pakistani national who, in connection with his albinism, had faced difficulty in obtaining and then maintaining employment, and he'd also at least once been beaten and called names by a group of men, non-state agents. He'd never sought police protection. That's paragraph 12 of the judgment. This is page 153. MI then didn't choose to leave Pakistan until 2 years after the attack, during which time he suffered no further violence. That's paragraph 64. And then, on arrival in the UK, made no reference to any past or feared persecution. And the question in MI's case is whether the combination of discrimination and also harassment by non-state agents, which he has suffered in the past and would suffer if returned, was persecutory. And that can be seen from paragraph 18, Roman numeral 2 of the judgment. And the answer of the Court of Appeal at paragraph 68 was that the Upper Tribunal had been entitled to find that that combination of discrimination and harassment by non-state agents was not persecutory. The other appellant was MF, a Venezuelan national who was seen as an opponent of the then president, Hugo Chavez. And the Upper Tribunal findings in his case can be seen at paragraph 33 of the Court of Appeal judgment. In summary, he had experienced harassment and intimidation on the part of people acting or purporting to act on behalf of the Venezuelan president. He had once experienced violence, and that had occurred when men, including members of the local police, tried to make off with his truck. And MF had stood in front of a truck and blocked the exit, upon which the truck was driven at him and hit him, and other members of the police intervened to stop this happening. This is paragraph 34. And the Upper Tribunal held that MF would have suffered no harm had he simply allowed the lorry to be driven away, but the harm was in a sense provoked by him. The Upper Tribunal also found that MF's claim to be on a list of President Chavez's opponents was not substantiated. So the question there was whether the combination of harassment and intimidation, including the particular circumstances where the truck is driven at him but he is standing in its way, amounted in the past to persecution. The answer at paragraph 74 of the Court of Appeal's judgment is that the Upper Tribunal had been entitled to find, but it did not. And if we now turn to the principles, if we look at paragraph 23 of MI Pakistan, this is page 156, we see that the judgment of Lord Justice Stanley Burnton in MA Ethiopia is cited. He had noted the unfortunate tendency in the law of asylum to treat findings of fact as decisions on point of law and binding authority. And we do say that the respondent appears to be in some danger of falling into the same error in this appeal. I shall come back to that. Lord Justice Stanley Burnton then goes on, this is paragraph 62 of MA Ethiopia, which is cited at paragraph 23 of the Court of Appeal's judgment in MI Pakistan, to say that whether ill treatment in a particular case constitutes persecution is a mixed question of fact and law. It's the application of a denotation of persecution to the particular facts. Then, and this is of particular importance to us, paragraph 24, the Court of Appeal then goes on to apply the principles in B, a child, noting that there are usually 3 stages to be taken by a judge determining whether a particular, in that case statutory, threshold has been crossed. First, determine the factual issues on the evidence before him, then identify the nature of the threshold, a question of pure law, then decide whether on the primary facts he has found and the assessments he has made, the relevant threshold has been crossed. And then if we look at paragraphs 26 to 28 of the Court of Appeal's judgment, we see that that 3-step process is applied to the question of whether past or future ill treatment constituted persecution in the case of MI Pakistan. And if I can just say how we say this applies to our case, we say that the first tier tribunal has erred at all 3 of those stages. And then, of course, the upper tribunal failed to identify or rectify those errors. So if for a second we reorder our 3 arguments so that we fit the MI Pakistan schema, first we say that the first tier tribunal did not determine the factual issues on the evidence before it as concerned future risk. Alternatively, and this is the way that the respondent quite properly puts it, alternatively putting it as a reasons point, the first tier tribunal, if they did make findings, those findings and the reasons for them were unclear. The second stage that's identified in MI Pakistan is application of the wrong threshold test, and we of course say that the FTT applied an incorrect threshold test, namely it considered that the treatment of the appellant had to be either persistent, in the sense of repetitive, or systematic, and I shall come back to the difficult question of what systematic was meant to signify there. Third stage, as identified by the court in MI Pakistan, is that we say that the overall evaluation of prospective risks of persecution in our case was flawed for those reasons, but also because the first tier tribunal had engaged in an erroneous analysis of past events. When looking at past events, we say that what the first tier tribunal clearly did was ask itself whether the past single beating, that was the phrase, was persecutory, rather than look at the effect of a beating in combination with arrest, formal charge, a formal criminal charge, blacklisting, surveillance, and the threat of rearrest, redetention in the near future. So the judge made factual findings about what happened in the past, but then failed to assess the past events and their consequences for prospective risk in the round. He just really asked himself, was the past single beating persecutory, and would the future single beating be persecutory? And I shall come back later to paragraph 56 of MI and the quotation there from Sepet and Bulbul when addressing you on the third argument. But could I ask you now, please, to turn back in time and go to the seminal case of Demir Kaya, which is at tab 3 of the main authorities bundle. It starts at page 13, main authorities. And this judgment concerned a PKK activist who sustained on several occasions detentions and physical attacks, 2 of which were particularly horrifying, at the hands of the Turkish authorities. The tribunal accepted that Mr. Demir Kaya's account of past events was credible, but did not accept that he would be persecuted on his return. And their laconic conclusion is excerpted at paragraph 13 of the Court of Appeal's judgment. That's page 17, main authorities. Their laconic conclusion was that on return, he may be insulted by the police and he may be beaten by them. Obviously, we do not know. Lord Justice Stuart Smith, with whom Lord Justice Laws and Lord Justice Parker agreed, said at paragraph 13 that the tribunal had not given its reasons clearly. He went on to say at paragraph 14, this is page 18 of the main authorities, I am left in doubt as to the degree and severity of such beating as the tribunal envisaged. If it was anything like that which he had previously experienced, I find it difficult to see that it did not amount to persecution. So when finding that the appellant in that case might be insulted and beaten in the future, the tribunal had given insufficient reasons for why this did not amount to persecution. Now, The Respondent's amended skeleton argument, paragraph 26, endeavours to distinguish Demiakaya and emphasises the appalling nature of the attacks that Mr. Demiakaya, in that case, had previously sustained. But past persecution, while indicative, strongly indicative of future risk, is certainly not a requisite to establish that an individual is a refugee. So the comment of Lord Justice Stuart Smith that if it is anything like that which he had previously experienced, I find it difficult to see that it did not amount to persecution, is emphatic. It's not, of course, stating a threshold requirement. The court might equally have said, in that case, if it's anything like the beatings suffering by persons in this category, as described in the country background evidence. So Mr. Demiakaya could have been someone who had never been beaten before. So they could have said, look, having regard to the background evidence, I find it difficult to see that this would not amount to persecution. So at most, what is being said there is a comment about materiality, as I shall explain in a moment. The key problem is that it's not clear what was envisaged. So the key point at paragraphs 13 to 14 of the Court of Appeal's judgment is that the tribunal in that case had accepted that there may be a beating in future, but made no findings as to its degree or severity, or no reasons for finding that the beating would not be persecutory. That was a legal error, and it was a material error in circumstances where there were good reasons to believe that the beating might be severe. And suppose we take another form of physical treatment, which, on the Demiakaya approach, the question of whether anticipated treatment amounted to persecution would be a question of fact and degree, and where, like a beating, a term could cover a multitude of different levels of gravity. Suppose the tribunal had found of a woman that it accepted that she might be inappropriately touched by the state authorities on her return, but that this would not amount to persecution. The court would surely say, well, what's meant here? What kind of treatment does the tribunal have in mind, and why is it not persecutory? Failure to make requisite findings or give adequate reasons for the final conclusion is a legal error.
The ill treatment in that case was described in paragraphs 4 to 6, wasn't it?
Sorry, 4 to 6 of the Court of Appeal judgment. Yes, it was absolutely appalling. He had been sliced with a bayonet, hung out of a window. But my point is, that's not a prerequisite. The problem is when you say...
Nobody says it's a prerequisite, but
yes.
It's the context in which that decision
Oh, absolutely.
sits.
But we would say equally, if you had had someone who had never been beaten before, but the country background evidence said people in this position are known to have been sliced with bayonets and hung out of windows.
There is an infinite range of possibilities in these cases.
Quite, yes. So, turning now to paragraph 15, Lord Justice Stuart Smith in Demiakaya cites Ravichandran, in turn citing with approval the formulation of Professor Hathaway in his earlier edition of his text, sustained or systemic failure of state protection. Turning to paragraph 16, what we can see is that in Demiakaya, the Appellants' Council advanced the argument that any beating at all will amount to cruel, inhuman or degrading treatment or punishment and is therefore persecution. And the court rejected that approach, observing this would tend to convert what is a question of fact into a question of law. The correct approach being that in Ravichandran, that matters must be looked at in the round. So then at paragraph 18, approving Professor Hathaway's formulation, we see the Court of Appeal saying that there is a scale. And at one end, presumably the most serious, there may be arbitrary deprivation of life, torture, and inhuman or degrading punishment or treatment. So it's clearly anticipated already in Demiakaya that a single instance of degrading treatment may constitute persecution. And in such a case, the conduct may be so extreme that one instance is sufficient. And then at paragraph 19, it would, I think, be open to a tribunal to find that a single beating, unless it was particularly vicious or injurious, does not amount to persecution. But if there's a real risk of repetition, the position would be different. So the Court of Appeal rejects the proposition that any beating in any context will amount to degrading treatment and therefore to persecution.
But this is what's said at paragraph 19 is an observation of fact. In the same way as the Lord Justice just said at paragraph 16, that we don't convert questions of fact into questions of law. Paragraph 19 is not a declaration of law either.
My lord, no, it's a rejection, though, of an argument that was advanced, of a bold argument, which is basically saying degrading treatment will always be made out where you have a beating.
But because we've seen paragraph 19 referred to in the skeleton arguments and in the judgments, it just strikes me, and I give you the opportunity to put me right about it, that Lord Justice Stuart Smith was not laying down a proposition of law here. He was illustrating his general position on this, which is that these are matters of fact that have to be assessed correctly in accordance with the law. But, I mean, this doesn't convert into the fact that one beating amounts to this, two beatings amount to that, and so forth. Of course it can't.
My lord, quite.
Right. So we gained the wisdom from paragraph 19 as an illustration of a wider point that the court was making in that case.
That it is fact-specific and context-specific, which is a point I shall come back to when we talk about the inadequacy, as we say it is, of the first-tier tribunal's determination. And then paragraph 20, we see that Lord Justice Stuart Smith notes the past treatment of Mr. Demikai was very relevant to the question of future risk, and cites with approval the comment of Professor Hathaway that evidence of past maltreatment is unquestionably an excellent indication of the fate which may await an applicant on return, unless there's been a major change of circumstances within that country that makes prospective persecution unlikely. Past experience under a particular regime should be considered probative. In sum, evidence of individualised past persecution is generally a sufficient, though not a mandatory, means of establishing prospective risk. So that's the formulation from Professor Hathaway, approved in Demikai, and of course we now have Article 4.4 of the Qualification Directive, approved by the Grand Chamber of the European Court of Human Rights in JK in Sweden, and reflected in 339K of the immigration laws.
Right.
And at paragraph 21, Lord Justice Stuart Smith says, no more than common sense.
And taking us to this because you're going to be arguing that the first-tier tribunal judge was wrong to find that the past treatment didn't amount to persecution.
Yes, although in a sense the label is only part of the problem. It's also, he actually had to look at all the past components of what had happened and bring those to bear on the assessment of future risk. And if I can borrow a phrase that actually appears in my lady's recent judgment case of AM, there's a break of reasoning, because he makes findings about the past and says, yes, formal charge, yes, arrested, yes, fingerprinted, yes, blacklisted. When he looks at the future, he only looks at single beating and possibly also looks at the blacklist. But for example, the formal charge drops out of the picture. So it is partly a point that he misinterpreted. Well, sorry, he mischaracterised past events with the result that he had the wrong starting point. But it's also that when assessing future risk, he's not bearing in mind the findings he has made about the past. Or to put it another way, I showed you earlier Article 4.4 of the Qualification Directive, cited in JK in Sweden, which says that direct threats of persecution or of serious harm suffice. You don't even have to show you were persecuted. If there's a direct threat that you will be, that is a serious indication of future risk, absent, of course, good reason to the country, such as democracy breaking out in the country of origin. But here, clearly we've got direct threats of future persecution or serious harm. The appellant is told you're going to be arrested and detained in the near future. He's subject to a formal charge. That is surely a direct threat of future persecution in the context where it is in connection with attending a peaceful demonstration. So my lady, I've run ahead of myself, but that was why we are labouring that point. And just before I leave Demikai, the last point in Demikai, which obviously doesn't apply to us here, was an application of the wrong standard of proof. But paragraph 26, once again, the lack of reasoning and explanation as to what the tribunal really had in mind, we say is a regrettably apposite introduction to what the first tier tribunal did in our case. And now I do intend to turn to that with apologies that has been a long journey through the
Not at
law.
all. Can I give
yes.
a bouquet to Miss Irving for sending in very nice open bundles, which are now in operation, at least here.
I'm very grateful indeed to my learned junior. So if we turn now, please, to the core bundle. This is the first tier tribunal's determination. And I'm turning now to our first argument, which is that the cursory conclusions concerning future risk fell far short of the findings that were required in a case such as this. So the core bundle contains the first tier tribunal determination.
112.
Yes. Right. And I apologise, I don't think this is tabbed either.
My electronic version of the core bundle is tabbed, hence me being able to get to it.
No, mine never suffered from any problems.
Yeah.
Right, so we're at the start of the FTT.
At the start of the FTT. So if we turn please to paragraph 7, my Lord Justice Dove, as President of the Upper Tribunal in the past, observed on a number of occasions, cases of TC and latter, the need for parties to identify the issues in the appeal. And here we see the issues being identified. That's paragraph 7, and for our purposes, it's 7 Roman numeral 1. And we see it's a broad issue. Has the appellant established to a lower standard that he would be at risk, presumably this is on returning to Vietnam because of his imputed political opinion? And I turn next to what was accepted by the first tier tribunal in relation to the account of past facts. So paragraph 8, we see that...
Could we, before we
Yes.
launch out, just identify what part of this decision is relevant to the issue that we're now concerned with. We have...
It's really down to 36, my lord. It's from where we are, but down to paragraph 36. After 36 is, we say, concerned with trafficking. But if I can just take you at a fairly brisk trot through the accepted points. Paragraph 8, not in dispute that the appellant is a Vietnamese Catholic who attended a demonstration about the Chinese occupation of the Spratly and Paracel archipelago and about the confiscation of church lands. Paragraph 21, and I'm reading in not in dispute because as you shall, I'm reading in that these are accepted facts because as we shall see in a moment, the first tier tribunal without reservation went on to find, despite concerns about lacunae and inconsistencies in the account, went on to find that the appellant was in fact giving a truthful account and that lacunae and inconsistencies were explained by his state of mind at the time of being interviewed. So paragraph 21, we see the appellant was stopped at a demonstration, punched in the face by the Vietnamese authorities. Paragraph 22 told the Vietnamese authorities that he was the leader of the small group of friends attending the larger demonstration. Paragraph 21, he was fingerprinted. Paragraph 21, placed on a blacklist. Paragraph 22, arrested and officially charged with an offence, namely attending an illegal demonstration. Paragraph 23, released, allowed to return to his home area, but told he will be arrested in the near future. Someone is sent to watch him. Parenthetically, you might think that this sounds like bail in combination with surveillance. Paragraph 28, while the appellant's prior account had lacunae and inconsistencies, his credibility is accepted without reservation. And then this is important for our purposes. Paragraph 32, we now see the first tier tribunal giving his overall summation of facts. Satisfied me he was arrested, also find he was beaten and returned to his home area where the authorities advised him that he was on a blacklist and they were watching him. So this distillation of the accepted facts omits the crucial point that he was told that he would be arrested and detained in the near future and that he had been charged with a criminal offence.
Well, I mean, it may be said against you that when in paragraphs 28, 29 and 30, effectively his account is accepted in toto, it wasn't thereafter necessary for the judge to repeat it all.
My lord, that might be right if we didn't have the problem that we've now got in paragraph 36, which I'm about to come to. So I can see that you'd have to keep repeating yourself as a judge.
You've just said it at paragraph 23.
But my lord, yes, but could I come on?
What are we speculating here? That the judge forgot between the moment that he drafted paragraph 23 and the moment that he drafted paragraph 32?
My lord, either he hasn't taken it into account, or he has simply given no reasons about why somebody who is formally charged and told he will be rearrested and detained, why those threats will not be borne out. So this was why I took you in part to Article 44, Article 4 of the Qualification Directive. There are direct threats. A criminal charge means you will be prosecuted. He's also told you will be arrested and detained in the near future. And I quite accept that the First Tier Tribunal mentions those. I mean, a mere few paragraphs later gives a summation that omits those. But
is there a system in the First Tier Tribunal where if a judge should unfortunately forget something, they can be asked to clarify what they've said?
My Lord Justice Dove will know this far better than I do, but there is a slip rule, but it would not be used to make a substantial amendment. So that would be quite a substantial amendment.
So it's a game that if somebody forgets something, you don't just point out that, Judge, did you forget I was arrested? You just appeal.
My Lord, I don't think it is a game, because if we think about the corrections process before this court, it wouldn't be appropriate to say you've missed something out that's quite substantial.
This is a trial court. This is a trial court, and certainly in the area in which I operate, it's perfectly commonplace for somebody to say, well, you've handed down this judgment, but we made 15 points, and we'd like to know the answer to point 13 or something of that sort. But why? I mean, I'm only asking as a matter of information. If this is so important that paragraph 32 doesn't reflect what was in paragraph 23, why doesn't somebody write to the judge and say, did you have this in mind?
My Lord, can I come on to paragraph 36? Because actually, I emphasise 32, but to show what I call the break in reasoning. But can I come to 36?
Right, so
because that's really where it crystallises.
Okay.
But if we look at the reasons, insofar as those go, they are at paragraph 36. They're all at paragraph 36, page 118 of the core bundle. As to past persecution, what the first tier judge says is simply this. In my judgment, the appellant has not demonstrated that he was persecuted in the past. I am not satisfied that the single beating was sufficiently serious. See, for example, Ali Chenkaya. And so the arrest, criminal charge, the threat of future detention, not mentioned here. So what is being looked at in terms of gravity for past persecution is the single beating.
No, it's not. That's not what paragraph 36 says at all. Look at the first 4 lines. The judge is holding in mind that the account that's given is that past persecution is accompanied by being on a blacklist, detention on arrival, further ill treatment, and questioning on return.
My Lord,
what's the questioning on return for if one isn't on a blacklist or have been arrested?
My Lord, he doesn't lose the blacklist, but can I just take this in stages, which is first to look at past persecution and then future persecution. So if we look at the past, the question he asks himself when he's looking at the question of sufficient gravity is the single beating sufficiently serious? If he was looking at single beating plus criminal charge plus arrest plus blacklisting plus surveillance plus threat of future arrest and detention, then it does fall to be explained why are those not sufficiently serious? Because, of course, as we saw earlier, persecution can be constituted by a single act, a single beating, for example, or by an accumulation of measures. So he doesn't actually say to himself, if I look at these things in the round, are they each, or at least cumulatively, sufficiently serious? He doesn't address his mind to that. So the first line is what counsel submitted. He'd been persecuted in the past, he's on a blacklist, he's going to be detained on arrival and entreated again. Then he comes to future risk, which I'm about to come to, but I'm actually trying to take it chronologically by saying, what does he say about the past first? The past, he doesn't look at the question of whether the cumulative effect, or each of those events taken in isolation, whichever it is, of beating, criminal charge, arrest, being placed under surveillance, being placed on a blacklist, whether those together constitute persecution. So, my lord, it's not, can I be clear, it's not my suggestion that he has forgotten. It's really that when he is asking himself the question, has there been persecution, or how serious was the past ill treatment, he actually doesn't look at the cumulative effect of all those events. That is my point, my lord. It's not that he suffered a terrible memory lapse in the course of 10 paragraphs.
Well, I think it's, I mean, yeah, as I say, what may be said against you is that, in fairness to the judge, you have to read the decision as a whole, and not parse the factual findings to.
My lord, yes, but then that's why it is important that if this isn't about findings, it is about reasons. Because if a judge doesn't think that beating, charge, arrest, threat of future arrest, surveillance, blacklisting, if he doesn't think that the cumulative effect of those is persecutory, why not? Because on any event, on any view, I beg your pardon, of the law, those were capable, if not bound to, constitute persecution when viewed together.
Yes.
And where is the explanation? Where is the reason? So, my lord, I quite take it that, of course, it's often being said one shouldn't subject determinations to unfair microscopic examination, but that's not what's being done here. It is really saying you've got to have the basic building blocks. And if the findings about the past are unsafe, then we say, of course, that fundamentally flaws the findings as to the future, because the wrong starting point has been adopted.
Well, the conclusion of the judge in the centre of this paragraph is that there is not a real risk of them taking any further adverse interest in your client.
And the basis on which...
That was his conclusion, because he's been here for 10 years.
And the reason why...
He hasn't done anything apart from go to one demonstration, apparently.
My lord, yes. But what he doesn't do...
But how do you deal with that finding? That's a finding of fact.
My lord, it is a finding of fact that omits the fact that this person is subject to a criminal charge and was told he would be arrested and detained in the future.
Who said he's subject to a criminal charge?
Sorry, who says so?
He was arrested.
No. There's a specific finding to that effect, my lord. Paragraph 22. The appellant added that he had been officially charged with an offence. At the hearing, he told me they had charged him with attending an illegal demonstration. And then paragraph 23. The police came to his house and said they will arrest him in the near future.
Thank you.
So we do say it's quite right that what the judge is essentially saying is, I don't really think you're going to attend any more demonstrations, and I don't, and nobody had said this is an HJ Iran type situation. So the judge does look at that, but what he doesn't look at is whether the various aspects of the past, which we say amounted to persecution, or at the very least to a direct threat of persecution, you've been charged, which means you'll be prosecuted. You will in the near future be arrested and detained. That is not brought to bear on the assessment of future risk. So let's see what he says about future risk. This is all in the same paragraph 36. He says, as I've accepted that the appellant was placed on a blacklist, I accept that the authorities may question him on return. And then he mentions the past beating. And then the first tier judge goes on, presumably only in relation to the risk of repetition of the beating, I've considered whether there's a risk of repetition. Given the background material, they might slap him or beat him again. But once they discover the appellant has been in the UK since 2014 and only attended one demonstration in 2018, there's not a real risk of them taking any further adverse interest in the appellant. And then we have the key summary. Although a further beating will be unpleasant, I'm not satisfied that the conduct will be persistent or systematic. So
That's not a summary. That's a further observation.
my lord, I actually, we would say that seems to be those are the only reasons. Those are the reasons. So it's not emphatic. It is a reason. Insofar as there are reasons, he is saying about all the reason he gives as constitutes the further beating taken alone.
He's giving a series of evaluations and explanations in the course of paragraph 36. I appreciate you disagree with them, but we're considering here what he's actually saying.
And we say, insofar as he looks at the future, he only looks at the only findings we have is you're on a blacklist, so you'll be questioned, and you may be slapped and beaten again. There are no other findings about context. So, for example, is he going to be detained? Where is he going to be beaten?
Well,
Is he going to be beaten?
How can the judge possibly answer those sort of questions?
My lord, in fact, that is, if I may say so, absolutely par for the course in this field. And one of the reasons why one...
Well, I can't possibly understand how such an exercise could be carried out. I mean, in the area with which I'm more familiar, we spend our whole time assessing risk, but we don't assess risk that relates, saying that there is a risk of this happening, and it will happen in this situation at that address at that time.
My lord, not at this address and that time, but...
Well, what else are you asking for?
Well, my lord, where somebody says... I mean, if we actually look at the start of that paragraph, we see counsel is saying he's going to be detained on arrival.
Yes.
And I will take you later to the material showing that in Vietnam, there can be, even for mere participation in a peaceful demonstration, so the most low-level participation one could have, there is the risk of prolonged incommunicado detention in poor conditions, and also, relevantly on the question of the criminal charge, extensive and wide powers to prosecute for mere participation in such demonstrations. But I shall come back to that. But we do say, where somebody says, I'm going to be detained, there does need to be a finding of, will they be detained? So for how long? So if you're saying someone's going to be hit, then one does need to make a finding, and it's absolutely standard that there are questions in the jurisprudence, and I beg your pardon that I may be straying close to giving evidence, but there are certainly many cases where it is a question of, well, will he be transferred to the national security forces, for example, who are known to be particularly dreadful in their torture? I'm not talking about the Vietnamese context. I'm just saying it is precisely the kind of assessment of future risk in which judges do engage in this jurisdiction. And the reason why there is a lower threshold is, of course, because of the difficulty of assessing prospective risk. But
Well,
where
it's a combination of that and also the the seriousness
Yes.
that can arise. But in this case, the judge, because he refers to it in his conclusions, but had referred in paragraphs 25 to 27 of the determination to the country information that he had been taken to,
Yes.
and which he brought to bear on the assessment of risk. So the assessment of risk isn't just what the appellant was telling him, it's the assessment of risk and what the appellant had told him, and he'd accepted, placed in the context of the country information that he was referred to, it seems, by both parties as being germane to the issue.
Yes, my lord, quite. But that doesn't negate the point. For example, let me just take you to a series of questions. Is he going to be detained or not? So we can see paragraph 36. The appellant's counsel says he's going to be detained. And I'll take you to other parts of the same report, which my lord has just averted, which show that is a serious question, given the conditions and duration of detention in Vietnam for the most minor participation in a peaceful demonstration. So is he going to be detained? How severe or prolonged a beating is this going to be? As I said earlier when I gave the comparison of sexual touching, this is a term that can cover a whole gamut of behaviour. What will be the impact on the appellant, bearing in mind that he left Vietnam as a consequence of his last beating, and he spent 3.5 years in captivity as a victim of trafficking? And going back to this question of is he going to be detained, that's important for the following reasons. First, as we saw, for example, from Regulation 5.1b of the 2006 qualification regulations, even if a measure taken on its own, such as a beating, is not persecutory, taken in combination with other measures, it may constitute persecution. So if one thinks of it as an equation, suppose beating does not equal persecution, beating plus detention may equal persecution. The second point that we make, which is really a related one, is that as concerns physical violence, the question of whether it's persecutory may hang on whether it is perpetrated upon a person deprived of their liberty. And that's not really a sort of A plus B equation. That's really that a beating is degrading in its effects in a different way, in a more serious way, where a person is vulnerable because they are deprived of their liberty. And we can see that from the Article 3 jurisprudence. I'm just going to take you for a second, if I may, to the judgment of the Grand Chamber in a case called Clyfia. And could I ask you please just to keep the first tier determination open? I don't know if that's possible for those working electronically. But Clyfia is in the main authorities at tab 11. This is another judgment of the Grand Chamber of the European Court of Human Rights. And if you look to page 302 to 303, paragraphs 158 to 160, paragraph 158 emphasises the fundamental nature of the prohibition of
Sorry, you've got to give me time to get to it.
I'm so sorry. I beg your pardon. Getting carried away.
302.
So this is page, I'm at page 302,
Yes, I'm there.
main authorities.
Yes.
And I was drawing your attention to 158 to 160. So paragraph 158 emphasises the fundamental nature of the prohibition of inhuman or degrading treatment and the way that this is bound up with respect for human dignity, of course in the same way that is the Refugee Convention. Paragraph 159 emphasises that ill treatment must attain a minimum level of severity if it's to fall within the scope of Article 3. And then the assessment of that level is relative, depends on all the circumstances of the case, principally the duration of a treatment, its physical or mental effects. Then paragraph 160 160 outlines other factors that the courts take into consideration. And 160A, we have the purpose for which the treatment is inflicted. I don't know what the purpose is of the beating here, but more importantly still 160B, whether the victim is in a vulnerable situation, which is normally the case for persons deprived of their liberty. So it really matters. Is he going to be detained or not? We say it's a fundamental factual finding necessary to assess whether the future treatment here, we say that the fundamental factual findings necessary to assess whether future treatment would be persecutory are missing from the first tier tribunal's determination in this case. And could I ask you to turn up, please, the case of Muhai, which is Supplementary Authorities, tab 3. I'm sorry, maybe mispronouncing it. And page 9, Supplementary Authorities. This was actually a judicial review case. And just by way of background, paragraph 6, 9 and 10, I won't ask you to look at them in any detail. The special adjudicator had actually even quite detailed reasons. But he had failed to make clear findings of fact as to the extent to which he did or did not accept the account of past ill treatment. And then Lord Justice Laws, with whom Lord Justice Clark, as he then was, and Lord Justice Wallow agreed, said...
Well, I'm just orientating myself in what's going on here. Paragraph 4.
So this is about a Kenyan national.
Yes, but I'm looking at the sort of ill treatment that was being alleged in that case.
Oh, I'm certainly not trying to do precisely what Lord Justice Stanley Burton deprecated in MA Ethiopia, which is trying to draw sort of factual precedents. I'm really relying on this for what it says about the failure to make key findings. So what I'm really relying on here is paragraph 13. It is elementary that on issues which are crucial to the case before him, an adjudicator should indicate, at the very least broadly, what evidence he accepts and what evidence he rejects. And at paragraph 18, we see that Lord Justice Laws sympathise with the view that on a fair reader, the adjudicator's findings of fact could be inferred, but it was not possible to be confident.
I'm not understanding how this applies to the present case. I mean, paragraph 13 is self-evident, the statement at the beginning of it, and I thought that we'd understood what past findings were accepted.
Yes.
And indeed, you've no complaint about it because your client's entire case was accepted.
Yes, but what's not found, where the factual findings are missing, my lord, is as to the future.
But factual findings about the future are not factual findings in the same sense.
My lord, they're not, and that's why.
Evaluations of what is likely to happen.
Well, my lord, another way of putting it is simply reasons. But we do say.
This case here, in the face of horrific alleged ill treatment, he wasn't terribly truthful, and there may be some truth in his story, but I'm not going to tell you what it is. Well, that's not what we've got here.
My lord, we do say what we are missing here.
Well, I understand what you say,
yeah,
but I'm just saying.
You don't see the application of these principles.
This lurid case from long ago, as it were, doesn't seem to me to shine any light at all on our task today.
My lord, can I then hand up a case that's not from long ago? It's on the same point.
We have another case.
Yes, and actually we've already given it to the respondent just in case, but this was just in case it was thank you. This is actually a judgment with which Lady Justice May will be very familiar, and it's a recent judgment.
Yes.
So, and it's a recent manifestation of the same propositions, if I may be so bold as to say so. But we do say, if my lord's not with me, that this can be termed findings of fact, then the other way to look at this is as reasons. But can I just take you here through the key aspects of this judgment? So if you look, please, at paragraph 26, the judgment is actually citing an earlier judgment of my Lord Justice Dove in a case called TC as President of the Upper Tribunal. So the FTT is required to identify the principal important controversial issues, marshal the evidence bearing upon those issues, and provide intelligible reasons for accepting or rejecting the evidence determinative of them. This is not limited to the past. This is also about the future. One has to make findings. And what we're missing here is a finding. Will he be detained? How long will he be detained? How severe is this beating that is envisaged? That's our point. And then if we look at paragraphs 29, first sentence, difficulty with determination here is it is impossible to discern from the reasoning what the FTT judge decided about the key indicia of risk. And then paragraph 30, uncertainty about what aspects of the account were accepted. And I completely accept that is about past events. And then a well-informed reader, this is still at paragraph 30, is left wondering which elements of AM's account the judge did accept and which he did not.
But that's not the case here at all.
My lord, no, my lady, I beg your pardon. No, not as to past facts, but as to the future. So we have the summary of what counsel who represented the appellant below said is he's going to be detained and he's going to be ill-treated. And what we have is no finding about detention. And then we have, he may be beaten or slapped, but I find that the further beating will not be persecutory.
But what was being proposed in relation to detention? That he was open to the court to reach a conclusion that there was a real risk that he was going to be detained without limit of time. Is it that sort of case?
My lord, when I take you to the background evidence, which I will
I'm not
do when I come to materiality.
Evidence. I'm talking about the real evidence relating to this individual. That, I mean, of course, there is always in countries that don't do it like us, there's always a chance that you're going to that things that are off the scale are going to happen. But that was not, as I understand it, the sort of thing that was being alleged by your client. What was alleged by your client is that they're going to go on doing what they did to me before.
My lord, no. No.
Where is the case that he was going to be detained indefinitely without charge or whatever?
Well, with charges, my lord. But my lord,
they're going to dig up the old charge and that he was going to be kept indefinitely. I mean,
my lord,
surely there's got to be some sense check on what the tribunal is dealing with in an individual case.
My lord, I will then take you to this particular report because
I'm talking about this case. At the moment,
but my lord, this report is one of the two reports that is cited by the first future tribunal judge. So it is the case that's before him. It looks from
reading the FTT decision that, as if what was suggested, when I get back, I will be arrested, I will be taken, and I'll be beaten up again in the way that I was beaten up before. That was what your client was apprehensive of, afraid of.
My lord, we do say that reading. Rather, I have to say, I did not appear in the tribunals below, so I can't try and reconstitute the argument.
We're going on the nature of the narrative that he stated and which the tribunal accepted.
But my lord, where someone is told you've been criminally charged, you will be arrested and detained in future, and one of the two reports that the first tier tribunal looks at does refer to prolonged incommunicado detention in circumstances where there are serious risks of appalling conditions and life-threateningly bad conditions and ill treatment. It certainly is incumbent on the judge to determine whether detention is going to materialise. It's, my lord, and we do say that this needs to be elementary, with the greatest respect. And in particular, where but it's actually not even necessary. Even if counsel were not saying he's going to be detained, it's self-evident. Someone's been criminally charged. They've been told just before their departure you will be arrested and detained in future. And you find they will be beaten. Where will they be beaten? Are they going to be slapped, punched in the face at the airport desk? Presumably not. So it is precisely the sort of engagement with future risk that decision makers in this particular jurisdiction, and it is a very particular jurisdiction, are required to engage in, which is what's going to happen? What is the real risk of what will happen? They're not crystal ball gazing, but they are assessing real risk. And if one is saying that a single beating, the further beating, will not be persecutory, then one needs to say, why?
Yes, I think
Yes.
you've got the point.
I'm sorry, I beg your pardon for repetition, but can I just just going back to my lady's judgment in AM, I had said,
I do, as you have rightly pointed out, know this case pretty well, but it involved an internally inconsistent judgment where the judge of the first tier judge had indicated that parts were agreed without, or parts of the he accepted parts of what had been said, but not other parts, without saying which parts he accepted and which parts he didn't. And that plainly isn't the case here.
not as to past facts, no, but as to what's going to happen in the future.
The future, as my lord's pointed out, future facts are not facts. They're an
Well,
assessment of risk.
Then my lord, then my lady, I beg your pardon. Then my lady, to put it in another way, one can look at this as a failure of reasoning. And just before I leave that, I had made the point earlier where I said even if counsel had not said he's going to be detained, it's an obvious issue. Paragraph 31 of my lady's judgment, if I can be forgiven to taking you back to a very familiar judgment. The ultimate responsibility lies with the judge to identify the issues correctly and marshal the evidence going to those issues.
Well, that was another problem with AM. The issue had not been correctly identified.
I might cavil at that. Actually, it's for the parties. The judge is not there to decide what the issues are. The parties are, and the whole process in the first tier is designed to focus the parties on what are the issues in the case. Now, you're going to take us in a moment to the report. I'm not sure. Well, we don't have the material that was before the judge. Did he have the whole of the report or just extracts?
He had the whole of the
He
report,
had the whole of
and
it.
actually we've even got the highlights that were in the report before him. So yes,
Yes. It was presented to
Oh, yes.
him with the parties highlighting.
I think it's probably the
Sometimes
appellant.
there are problems in relation to what actually was before the judge.
No, this is not such a situation. We've
I
been
just
very
wanted to clear
careful
that
to
up. Yeah.
try and go back and excavate past bundles
Yeah.
to check for that. So can I so that there's a fundamental objection, I think, to me calling this a failure to make findings. The other way we can put this is simply a failure to give reasons. And that's the way in which the respondent deals with this at paragraph 29 of the respondent's substitute skeleton argument. They cite English and Emery Reinbold. And the famous passage to which the respondent is referring is, of course, the dictum of Lord Phillips, Master of the Rolls, at paragraph 19 of that judgment, where he said of a requirement to give reasons, this does not mean that every factor which weighed with the judge in his appraisal of the evidence has to be identified and explained, but the issues, the resolution of which were vital to the judge's conclusion, should be identified, and the manner in which he resolved them explained. And the issue, coming back to my Lord's point, the issue identified by the parties, which is at paragraph 7, Roman numeral 1, is whether the appellant will be at risk of persecution on return to Vietnam for reasons of imputed political opinion. Specifically says, I will be detained in ill treatment. He's found entirely credible as to past events. There's no suggestion that country conditions have improved. His protection claim is rejected. And we say in these circumstances, it is necessary for the first tier tribunal to identify and resolve the vital questions. Will detention transpire? If it will transpire, why is it not, taken alone or taken with a beating, sufficiently serious to be persecutory? It being accepted that ill treatment may transpire, how severe or prolonged will that ill treatment be? Again, taken alone or alongside any detention. What's its impact going to be on this individual? And why will the criminal charge lead to no ongoing adverse interest? And the respondent says that the English and Emery-Reinbold test is met. And we say that what the respondent does is cleverly but impermissibly try to construct from implication or from different parts of the first tier tribunal determination, which in fact concern distinct issues, findings or reasons which are in reality missing. So I'm just going to read out what the respondent says, and it's telling that this is the way in which the respondent has to put it. The reference to the beating occurring under questioning by the authorities, whether under arrest or not, can only be understood as with the appellant being detained for the purposes of such questioning. Indeed, detention appears to be accepted by the first tier judge at paragraph 36. But whether the appellant would be detained, and if so, for how long and where, is in reality entirely unclear from paragraph 36 of a determination, at any part of a determination. And these kinds of assumptions appears to be accepted are not permissible where anxious scrutiny applies, which of course it does here, and I shall come back later to the question of anxious scrutiny. And if you go back, please, to paragraph 36 of the first tier tribunal determination, called bundle page 118, what the judge actually said was counsel submitted that the appellant had been persecuted in the past, and as he's on a blacklist, he'll be detained on his arrival and treated again. As I have accepted he was placed on a blacklist, I accept the authorities may question him. And this error is material, we say, for reasons I shall come back to. In the alternative, of course, if the respondent's right that he's going to be detained, then that renders only more concerning the failure to explain how long, in what conditions is he going to be detained, or why detention plus beating is not persecutory. We don't have any reasons for this.
Okay.
And there's also, I'll just take this point quickly, but the respondent also argues that the appellant's subjective vulnerability to withstand a further beating was rejected. And that the respondent says that at paragraph 28. But in fact, what the respondent is doing is selecting apart from a separate part of the first tier tribunal determination, paragraph 39, which isn't about overall vulnerability. It's about vulnerability to being re-trafficked in the sense of a person being so incapacitated that they cannot work and therefore throw themselves at the mercies of traffickers. And the meaning can be seen if one looks at paragraph 39. Given the economic situation, I accept it would be difficult for the appellant to find work. The appellant's a healthy young man who spent the first 3 years of his life in Vietnam. Although he left Vietnam about 10 years ago, is not suggesting he's no longer familiar with Vietnamese culture and society. Further, given his experiences in the UK, he would be sceptical of offers of work in Europe. So what we have at paragraph 39 is an analysis of whether he is specifically vulnerable to re-trafficking, not how will somebody who has spent 3.5 years as a captive, how is he going to experience beating with or without detention?
So the analysis at paragraph 39 of trafficking has stood muster because there isn't an appeal.
Well, it's not been challenged.
No, it's stood muster.
Yes. Well,
Right,
I think it was challenged to the Upper Tribunal and then not beyond, yes.
Yes, but the analysis at paragraph 36 doesn't pass muster.
Precisely.
That's the way you put it.
Yes.
Thank you.
And we do say, of course, it would be an extraordinary and irrational finding if, contrary to what I've just said, the respondent is right that the judge was saying he's not going to be in any way vulnerable to the effects of a further beating, because it's accepted that he's a victim of trafficking, and we've given you the references, I won't labour them, for it being generally accepted that victims of trafficking are a vulnerable class. And that's, of course, a foreshortening, where you've got someone who has spent 3.5 years of captivity. So, in other words, what we are relying on here is that the tribunal must make findings or give reasons on issues whose resolutions are vital to the judge's conclusion, and to explain the manner in which those were resolved. And that simply does not happen here. Turn now to the second argument.
Before you do,
Yes.
do you think it would be useful for us to have TC as the argument is now developed into a reasons point?
TC,
Yeah.
my lord, certainly, and I think that my learned junior may have TC at her fingertips.
I had no reason to doubt that.
I can email.
And it can be emailed,
Thank you.
and I will perhaps therefore open it as well. And can you send it also to
I don't need,
Yes.
yeah, I just think in our kit bag,
Yes.
it would be useful given it's been referred to.
My lord, I'm very grateful for this suggestion. The second argument is that the first tier tribunal erred in its approach to past persecution, rendering its findings as to future risk unsafe. You already saw the two sentences used to dispose of past persecution. He has not demonstrated that he was persecuted in the past. I'm not satisfied that the single beating was sufficiently serious. And of course, the point here is that on the first tier tribunal's own findings, this is not a case about a single beating. It's about a beating plus arrest, formal criminal charge, blacklisting, fingerprint release, and then in another geographic area, surveillance and a warning of future rearrest in connection with attendance at an illegal demonstration. Why is that not persecution? Or to put it another way, why is an accumulation of various measures, why is this not an accumulation of various measures which is sufficiently severe so as to affect an individual in a similar manner to a severe violation of a basic human right? I'm citing, of course, Regulation 51B of the 2006 regulations. And we say that the result of this, because of the great importance that we can see in Article 4.4 of the Qualification Directive, in the Grand Chamber's judgment in JK and Sweden, and in Demir Kaya, and in Lord Walker's judgment in HA Iran, the great importance that is attributed to past experiences of serious harm, all the threat of these. One needs to explain, at the very least, why these facts do not give rise to future risk, and we are simply missing this. And a particularly glaring point is what happens to the criminal charge and the previous threat of rearrest. So the appellant isn't just someone who's been blacklisted and beaten. Those are the two features singled out of paragraph 32. He's been formally charged with a criminal arrest. And we say that does beg the question of why is there not adverse interest because of this? And it may be that the judge would have had reasons, but here they don't appear, and it is not appropriate, we say, for an appellate court to try to infer those.
But he's already referred at paragraph 25 to the country policy information note on Vietnam.
Yes, my lady.
Which identifies precisely, it seems, what happened to,
Well,
to
my
this
lady, and
man,
if we look
and
at
says, in general, it's not sufficiently serious by its nature or repetition to amount to persecution.
And if we
Why is
look
it not
at the
allowed to take
question,
that into account?
and then my lady, can I just show you 3.2.1 of the excerpt that you're looking at?
Yeah.
Whether a person is likely to be at risk of persecution and or serious harm will depend on, and then there are a series of factors given: level of involvement, activities, nature of any criticism, topics they've been critical about, and any previous adverse interest.
Yeah.
And so we say this is someone who has come to serious adverse interest. And so we say it is certainly something that needs to be explained, why the past formal criminal charge, the threat of rearrest, redetention, does not place him at risk. And it is notable that the respondent skeleton argument at paragraph 30, when trying to explain the reasoning of the judge, says, well, blacklisting hasn't been left out. But the respondent actually completely omits reference to the charge. So the respondent has completely missed the criminal charge, but also, if we look at the Upper Tribunal judge's determination for a moment, this is core bundle page 92, paragraph 14, we look at how the Upper Tribunal judge interprets it. The Upper Tribunal judge summarises the first tier tribunal's findings on past persecution by saying the appellant had not demonstrated he was persecuted in the past, as it was not accepted the single beating was sufficient to amount to persecution. And we agree that is what he found. When he was looking at past ill treatment, the focus was only on the single beating. That's not a question of him forgetting, having a sudden lapse of memory. It's just there is a lapse in reasoning. There is a break in the reasoning. And it is telling that the respondent entirely misses the point that the appellant was subject to a formal criminal charge. You look, for example, at paragraphs 4 and 30 of the respondent's skeleton argument. And tellingly, it's not just a jury point, is that the upper tribunal falls into the same omission. So nowhere in the upper tribunal determination is there any reference to the formal criminal charge imposed on the appellant before he fled Vietnam. Now, we say, and we understand that to be common ground, that it's clear from paragraphs 28 to 31 of the first tier tribunal determination that the appellant's account of past offence was accepted in its entirety, including the criminal charge. But if what the respondent is really saying by omitting the criminal charge completely is that it wasn't accepted, then that doesn't assist the respondent. It would suggest that a fundamental finding as to past events was unclear. And this is not the kind of microscopic searching for errors that has been deprecated for the courts in cases such as H.A. Iraq, to which I believe the respondent will take you. So it's an elementary failure to make findings or give reasons. And it's particularly concerning in a case that concerns the risk of serious irreversible harm. Could I ask you please to look at, in the supplementary bundle, the case of M.N. Somalia, which is at tab 5.
Before we do that, can we just look
Yes,
at what was argued before the upper tribunal, the ground that was argued? We'd find that at paragraph 18 of the upper tribunal's decision, on page 92 of the core bundle. Round 3 asserted that the judge's findings regarding risk on return were not sustainable on the basis of the failure to give reasons why the conduct the appellant would experience on return in beatings were not persistent or systematic, why conduct had to be persistent or systematic for it to be persecutory, and failing to consider that if the appellant is on the blacklist, he will be arrested, detained, questioned, and subject to persecutory treatment.
Yes.
And that's what the upper tribunal was being asked to focus on, the beatings and the blacklist, and what the blacklist imported in terms of arrest, detained, questioned, and subjected to persecutory treatment.
My lady, I'm simply making the point that it is telling that both the upper tribunal and the respondent summarise the facts without any mention of the criminal charge. So if we look up the page, of page 92...
My point is that they weren't being asked to. There wasn't a complaint about that before them for the upper tribunal to consider. The complaint was, you haven't justified why the beatings weren't sufficiently persistent or systematic, and you're failing to consider that if he's on a blacklist, he's going to be arrested, detained, questioned. I mean,
my lady, yes.
They were being asked to focus on those as deficiencies. There was nothing said there about a failure to deal with charge.
My lady, I hope I'm not being misunderstood. I am not here to challenge the upper tribunal's determination, save to say they failed to identify and rectify the errors of the first tier tribunal.
No, this is the ground that was being put before the upper tribunal to consider. But we, obviously, are looking at an appeal against the upper tribunal's, what the upper tribunal did in relation to that ground.
But my lady, so what you're referring to at paragraph 18, which was ground 3 before the upper tribunal, yes, actually is what I'm about to come to, which is our argument 3. So you anticipate where I'm going next, which is that point. But before I go there, in answer to my lady's question, if we look at paragraphs 11 to 12 of the upper tribunal's determination, well, it's actually 7 to 12, that is how the upper tribunal understands the factual matrix. My point is simply that when one reads the determination and the respondent with their experienced counsel have fallen into the same problem, one is missing consideration of the effect of a formal criminal charge. That's all I'm making.
Yes,
that's the only point.
The point that my lady is making, which so far I don't think you've dealt with, is that you've spent quite a lot of time before us making a complaint about the charge which was not made to the upper tribunal.
My lord, I would respectfully say that when one is saying someone's going to be detained, that does comprehend the question of a criminal charge. So he's told...
The point that you've been repeatedly making is that the judge in the first-tier tribunal did not take sufficient account of the fact that your client had given an accepted account that he had been charged.
Well, my lord...
And also, you've made a number of other points to do with cumulative effect of
yes.
various elements, but one particular point that you emphasised was that no account was taken. You don't say it was because it was forgotten, but it simply wasn't taken into account that he had been charged. My lady is simply making the point that that was not the complaint that was made to the upper tribunal by counsel who had been in the first-tier tribunal and was in the upper tribunal.
And my lord, I take the point, although I would respectfully say that the question of whether somebody will be detained comprehends the question of why they will be detained. We have to focus on the fact is, I mean, in considering how good your point is about the charge, we have to contemplate the possibility that it's a key point in the appeal to us, but it had escaped those who were representing anybody in the, not only the appellant, but also the tribunal itself in the upper tribunal. But there we are. I mean, that's how and it's escaped the respondent as well. My point was simply, it is that
well, I think
yes.
I mean, the point to build on that point, page 104 of the core bundle are the grounds of appeal, and in particular ground 3, and there is no mention of a charge at all. And to break back to the points being made in TC, the whole point of the process is to identify the principal controversial issues. And I think what my lord is putting to you is it makes it difficult for this court to perceive that as being a principal controversial issue if nobody has ever identified it until your fresh eyes were brought to bear on the case. But we have your submissions.
My lord, yes. And I can only repeat what I have, which is to say the question of whether someone will be detained can reasonably be taken to include the question of whether that arises as the consequence of them being threatened in the past with arrest and detention, which was one of the accepted facts, and them being formally charged.
Okay.
My lord, turning next.
How are we getting on, Mr. Binsky?
My lord, I shall finish my lunch, which is what
Thank
I
you.
had promised. Well, subject to questions, I should say, but and it may be that there are many. But could I take you, please, to the supplementary authorities and MN Somalia, which is a Supreme Court judgment. This is at tab 5. And I ask you only, please, to look at paragraph 31. So this is the judgment of Lord Carnworth, with whom Lord Newburger, Clark, Lord Hughes and Lord Hodge agreed. And it is explaining what is meant by anxious
Sorry, where are you
scrutiny.
taking us?
I beg your pardon.
Supplementary authorities
Yep.
bundle, page 38.
Thank you. So this refers to the special responsibility carried by the tribunals in the context of asylum appeals, customary to speak of the need for anxious scrutiny. And then Lord Carnworth cites his own earlier judgment. The expression is uninformative, read literally. The words are descriptive, not of a legal principle, but of a state of mind. However, it has by usage acquired special significance as underlining the very special human context in which such cases are brought, and the need for decisions to show, by their reasoning, that every factor which might tell in favour of an applicant has been properly taken into account. And then, of course, it said this is a principle, of course, that cuts both ways, that may assist the Secretary of State. But I'm sure the court has my point, the factor of the criminal charge is missing, or if the objection is taken against me that detention does not comprehend a criminal charge, the factor of detention is not addressed. Either when considering whether the past treatment was persecutory or when considering whether the future treatment will be persecutory. In fact, we don't know whether detention in the future is accepted. The respondent has tried to get around that problem by saying, oh, well, we've got to assume that it is accepted. But if it is accepted, why is it not persecutory? And the other point that the respondent makes in response to us, this is their skeleton argument, paragraph 31, and they say, well, look, the first tier judge cited the case of Kaya, which was a permission judgment. I won't ask you to turn it up. But it said, well, in Kaya, the facts show that there was an assessment of the cumulative effects of events. But that's an enterprising but thoroughly unconvincing argument. It's an old judgment on permission. Permission to cite it was granted in relation not to the definition of persecution, but to the appeals test. The word cumulative nowhere appears in Kaya, unsurprisingly, as it predates the qualification directive. And in reality, what Kaya seems to have been cited for at paragraph 36 of the first tier tribunal's determination, when read in context, is that the first tier tribunal treated Kaya as authority for the proposition that a single beating need not constitute persecution. So that concludes what I have to say on the second argument, and I now move to the third point. So we say that the first tier tribunal applied an erroneous threshold test. And if you look at paragraph 36, please, this is the key paragraph of the judgment, the determination below. This is page 118 of the core bundle. There are no findings, if I can be permitted the word, or reasons relating to the duration of further beating, its severity, its context or its effect. That was the first argument you just heard from me. The only reason given by the first tier tribunal for the conclusion that the future treatment would not be persecutory relates to the question of persistence. He says there's not a real risk of them taking any further adverse interest in the appellant. And we said that that finding is unsafe for the reasons given in our second argument relating to the blacklist, the pending criminal charge, and the threat of further arrest and detention. But let's assume, for the sake of argument, that there is a legally sustainable finding, that there would be no future adverse interest beyond a beating, and then in parentheses, maybe with detention. The only reasons for the first tier that the first tier tribunal gives for why the further beating is not in itself persecutory is the words, I am not satisfied that the conduct will be persistent or systematic. So that is being treated as sufficient basis or reason to find that the further reason is not persecutory. He treats persistent or systematic as a threshold test. It is not a permissible threshold test. So what the first tier tribunal should have had in mind, and may have had in mind actually, was Professor Hathaway's test, which you saw was repeatedly endorsed by the higher court. You saw Lord Hope and Lord Dyson, for example, in H.J. Iran. And we will also see that it's been endorsed by Lord Hope and Horvath and by Lord Bingham in Seppert and Bulbul. But Professor Hathaway's formulation is sustained and systemic, not systematic. And of course, there's a fundamental distinction between systemic and systematic. This is not dancing on the head of a pin. Could I ask you to look at authorities, please? Main authorities, tab 14.
Sorry, what do we, just so I've got this in focus. The issue that we're concerned with here is, on the one hand, first tier tribunal persistent or systematic.
Yes. On the other hand,
And the other hand is sustained and systemic.
sustained or systemic.
Sustained or systemic,
not
and
conjunctive.
you're about to tell us the difference between those.
Yes, and we don't have any objection to persistent because it can be persistent,
Right, so
can be one feature.
So we're down to the difference between systematic and systemic.
Yes, and if you look please at page 388 of, and this is tab 14 of the main
Authorities bundle.
I beg your pardon, main authorities, yes.
Thank you.
Tab 14, page 388.
And here we're quoting from.
Yes, so this is the last paragraph on page 388. This is Professor Hathaway.
Yes.
This is the recent edition of his work. So the edition that is being frequently cited in the House of Lords cases is the earlier edition, this is the later one, of his seminal work, The Law of Refugee Status. And Professor Hathaway says, so long as the risk of denial of a broadly accepted international human right is sustained in the sense that as a practical matter it is ongoing, or systemic in the sense that the risk is endemic to the political or social system, can reasonably be said that there is a risk of being persecuted. So it is clear that what is meant by systemic, by Professor Hathaway, is endemic to the political or social system. But let's turn back to systematic. It's not at all clear what the first-tier tribunal judge means. If he means systematic means repetitive, there's of course no...
Systematic means that it's done by the system.
Well, my lord, actually, we went so far as to check the Oxford
Yes.
English Dictionary.
But I mean, I have to say, I mean, I don't want to stop you, but I mean, I think we're here getting into there's an air of unreality about this.
My lord, no. If I may be so bold as to say so, if we think about systematic does not mean inherent in the system. Systemic does. But if he meant systemic,
Systematic means organised.
yes.
Right.
And there is no need.
Organised by whom in the context of this case, other than the state?
But well, quite. If he meant so systematic can mean a number of things. It can mean repetitive, no requirement for that. It can mean coordinated, no requirement of that. If it means endemic in the system, then as I shall show you, it was not open to him. It was not open to the first-tier tribunal to find that detention and violence in relation to persons seen as critics of the Vietnamese state, even because they had participated or even prepared to participate in, we shall see, a single peaceful demonstration. It was not open to him to find it wasn't inherent in the system. But that's actually not the word he used. So we don't know, does he mean repetitive? Does he mean efficient, methodical, or coordinated? None of those are requirements. Now, the respondent doesn't suggest that this is a slip of the word processor. I mean, if he had meant inherent in the system, i.e. systemic, that would be correct as a matter of law, but that's clearly not what he means here. If he had meant intentional, that would also be correct as a matter of law, but it's clearly not what he means here. The evidence before him was that the beatings, detentions, surveillance, a plethora of forms of ill treatment are endemic in Vietnam as concerns persons in this class. So we do say that this is very far from being pedantic nitpicking. I'm going to take you in a moment to materiality, but before I do, I just want to show you the part of MI Pakistan that the respondent relies upon. So this is page 171 of the authorities. The main authorities, I beg your pardon. So this is MI Pakistan, paragraph 56, and this is quoting Sapat and Bulbul, the judgment of Lord Bingham. So Lord Bingham, and you can see it's bolded, and I think it's bolded in the Court of Appeal judgment rather than the House of Lords judgment. The respondent may assist us with that. But we have the bolded passage refers to the Oxford English Dictionary definition of persecution, a particular course or period of systematic infliction of punishment directed at the professors of a religious belief. So that's where we see an appearance of the word systematic. In other words, the word persecution, according to this dictionary definition, is redolent of a treatment meted out, for example, by the French to the Huguenots. But that's not, of course, the Refugee Convention definition, nor is it the one in the Qualification Directive, nor is it the one adopted by Parliament in Section 31 of the Nationality and Borders Act. Not least, as of course the Refugee Convention is not exclusively concerned with beliefs. And nor did Lord Bingham suggest that. This bolded passage is about the strength of the word. Persecution is a strong word. And he observes that the dictionary definition accords with popular usage, not legal usage. And he then goes on to state, and this is about legal usage, that valuable guidance is given by Professor Hathaway. And then we get the sustained or systemic failure of state protection. So it may well be that the first tier tribunal thought that the correct test was the one that's cited from the Oxford English Dictionary, not the one from Professor Hathaway. But far from that being a saving grace, that's an error.
Okay.
Now, I had said I would turn to materiality, and I shall race on to that because I don't want to trespass on time. Before I do, though, one point I do particularly want to address is that, actually, 2 points I shall make, sorry, that the respondent cites a number of cases, Kaya, MI Pakistan, and a case called Nyengu, which is about non-state violence. It's not clear what point is sought to be made by the respondent. There is no notion of factual precedent here. There are very specific, of course, concepts of factual precedent in country guidance, where one's looking at a particular category in a particular country. That's far from being the situation here. We're being cited judgments that refer to completely different contexts. The respondent also suggests that this third argument can only succeed if the first tier tribunal's conclusion was outside the range in which reasonable agreement is possible. That's paragraph 34 of the respondent's amended skeleton, but that's simply incorrect. If we're right that the first tier tribunal applied the incorrect threshold test, of course, that's a question of pure law. It admits of only one answer. There can be no reasonable disagreement. And I had said that I was focused on the first tier tribunal's determination. If you consider that the first tier tribunal erred in law, that suffices for our purposes. Much more briefly, I'll make 3 points about the upper tribunal. First, the upper tribunal noted that the case pleaded before the tribunal below concerned a risk of future detention, that's paragraph 14, upper tribunal, but failed to identify the problem that there was no finding concerning whether or not detention would materialise, if so, for how long and in what conditions, or if detention was accepted, why it would not constitute persecution. Second, I've already said, as to the question of whether there was past persecution in the past, we agree that the upper tribunal rightly identified the finding as being a single beating, but it fell into the same error of failing to look at the cumulative circumstances that, taken together, at the very least, if not taken alone, were capable of amounting to persecution or serious harm. And then third, as to the incorrect threshold test, my lady already took us to paragraph 18, where the ground indeed did squarely challenge the first tier tribunal's formulation of persistent and systematic, saying, why does it need to be persistent and systematic? And if that is the test, why is it not met? But the upper tribunal recites that ground, but then does not actually resolve it. But I turn now to materiality. And there are 2 points to the points I will make on materiality. One concerns the background materials, which I've mentioned a number of times. So this is the report that was in its entirety before the first tier tribunal, and I know because my learned junior even had to scratch out the page numbers, and so the highlighting is not ours; it's from either the first or upper tribunal below. So this is a supplementary bundle starting at page 2. Could you turn please to page 4 and see the first and last highlighted passages? So systematic repression of right to freedom of right to peaceful assembly, and includes unnecessary and disproportionate use of force, arrest, detention, prosecution, other forms of attack and harassment against protest leaders, participants and sympathisers. And then the last paragraph, numerous national security provisions of the criminal code have been frequently used to arrest, detain, prosecute and imprison demonstrators and civil society members. And then, yeah, sorry.
The judge quotes that in the first tier tribunal judge quotes that.
Yes, but then if we look at, but we do say that this really raises the question of what is being found about future detention, the risk of future detention,
Yes,
and if it's
does
accepted.
the judge is extracting 3 paragraphs from paragraph 25 of his decision. Is there any complaint about what he has extracted?
So actually, paragraph 25 is another judgment. So, sorry, I beg your pardon, another report. The passage he extracts from this report is at paragraph 27.
27.
So this isn't a complaint to say he should have cut and pasted the whole report in. By no means. I am making a point here as to materiality, which is if the court is with me on any of the 3 classes of error that I have identified, the error is material because if we see that, and this is, for example, page 5, second paragraph, individuals who are arbitrarily arrested, detained and prosecuted in connection with their involvement in public assemblies are often face further abuses, including denial of the right to fair trial, disproportionate prison sentences, poor detention conditions, ill treatment and torture in custody, constant police surveillance. In some cases, poor detention conditions and ill treatment have been fatal. So, in other words, it is not semantic nitpicking when I say, is he going to be detained? If so, for how long and in what conditions? And why, if he is going to be detained, why is detention taken alone or detention plus beating not persecutory? We say properly approached. This is a case that certainly could, if not was bound to, succeed, but certainly was capable of it, which is all I need to show you for materiality purposes. And if you turn now to page 8, please, here you see a recitation in this report of various provisions of Vietnam's criminal code which are used to criminalise protest, including peaceful protest, and which carry harsh sentences, including periods of imprisonment, and in 6 instances also a death penalty, although that doesn't form part of our case. But if you look at the first and second paragraphs on page 8, and if you look at paragraphs 109, 331 and 118, and in 118, bear in mind, of course, that the appellant confessed, possibly falsely, to the Vietnamese authorities that he was the leader of his small group of friends, and look at article 318. And then at page 10, you see the reference to Circular 9, the many circumstances in which a protest may be forbidden. Penultimate paragraph, page 10, the power locally to detain persons suspected of disturbing social order and safety and to detain them in compulsory education establishments for periods ranging from 6 months to 2 years without due process. And then please see at page 26, under the heading, persecution of peaceful protesters, acts of repression have included threats and intimidation, arbitrary arrest and detention, denial of the right to fair trial, disproportionate prison sentence, constant police surveillance. In some cases, poor detention conditions and ill treatment have been fatal. And then, still at page 26, please look at the 4 paragraphs. I beg your pardon. I'm sorry, at page 27, if you could look at the paragraphs under the heading unlimited pre-trial detention and prolonged incommunicado detention. So my Lord Justice Jackson said, well, is there any evidence really, if I understood correctly, that there is a risk of prolonged detention? Was that really an issue? And we say, well, yes. In circumstances where this is the report that's being relied upon, yes. We don't have to go so far. Doesn't have to be detained for years. The question of whether someone's been beaten in police custody itself may be persecutory, and I'll come on to that in a moment. And then page 30, under the heading torture and ill treatment, individuals involved in protests have often been subjected to torture and ill treatment in custody. So clearly, this is a case where getting it wrong carries the most serious potential real-life consequences for the appellant. But still on the subject of materiality, I shall turn very briefly, if I may, to the question of how the law treats physical violence and degrading treatment. Now, my lords, I probably am 5 minutes behind. Is this a convenient moment to stop, or should I press on and go as fast as I can?
Carry on.
Thank you, my lord. So there are two sub-points as to the law on physical violence and and degrading treatment. The first one is the one I already drew to your attention. But on the respondent's own analysis, the first-tier tribunal may have accepted there would be detention as well as beating. The respondent's analysis seems to be that neither of those sufficed. And we've, of course, added the further point that there may also be prosecution. But those various measures, even if one takes criminal prosecution out of the picture, clearly do constitute, or at the very least are capable of constituting persecution. So that's the point about materiality, that if we had a clear finding on detention, which the respondent doesn't suggest there's a clear finding, but says it must be presumed to have been accepted, then it was clearly capable of constituting persecution. The further point I make is that a single beating may constitute degrading treatment where it takes place in custody, and that, as I've already indicated, degrading treatment is sufficient to establish persecution. And could I ask you please to turn up authorities, main authorities, tab 14. And this is page 402 to 403. So this is Professor Hathaway again. We're back into his most recent edition of his seminal work, The Law of Refugee Status. Bottom of page 402, top of page 403, Professor Hathaway notes that the prohibition on torture and on inhuman or degrading treatment or punishment continues to apply in a state of emergency. It's non-derogable. And then at page 404, last paragraph of page 404, paragraph starting in sum, freedom from physical violence is a central component of the right to security of the person. So this is a theoretical underpinning from Professor Hathaway for the point that we already saw in, for example, the Grand Chamber's judgment in Y&Z and also in Demekaya, that a single instance of degrading treatment and of physical violence constituting degrading treatment may amount to persecution. And can I ask you now, please, to turn up the case of Buyid. This is at Main Authorities, tab 10. This is a judgment of the Grand Chamber of the European Court of Human Rights. And I'm taking you to this judgment, I beg your pardon, to show you that slaps or beatings to the face against a person deprived of their liberty have been held by the Grand Chamber of the European Court of Human Rights to amount to degrading treatment. Now, I had myself said there's no such thing as factual precedent, but as you will see, the Grand Chamber here isn't just talking about the facts, it is laying down principles concerning the degrading element of beatings to the face, the degrading element of beatings in custody. So, to take you very briefly through the key passages, at paragraphs 45 to 47,
Page.
I beg your pardon, 219
Thank you.
to 221, there is an emphasis on the centrality of human dignity to international human rights instruments. And again, of course, that is a vital common feature between the European Convention of Human Rights and the Refugee Convention. Paragraph 81, the Grand Chamber emphasises the fundamental, absolute and non-derogable nature of the prohibition of torture and inhuman degrading treatment, and how closely bound up this is with dignity. At paragraphs 86 to 89, we see further analysis of the relationship between human dignity and the minimum level of severity required for ill treatment to fall within the scope of Article 3. And then at paragraph 88, reference to recourse to physical force by law enforcement officers which is not strictly necessary and where the individual is deprived of his liberty, reiterated at paragraphs 100 to 101. And the facts in that case were that there had been a campaign in effect by the Belgian police against two youths, and they were slapped in the face and bore bruises. So they suffered minor injuries, not on the Demikai level. Paragraph 104, particular emphasis on a slap to the face, which of course you may remember it had been accepted that the appellant in the past had been punched to the face. So we actually don't think that there is a finding about what kind of beating there will be in the future. But my Lord Justice Dove said, well, isn't he really just saying it's going to be the same? But if it is the same, then it's a punch to the face. Paragraph 106 to 107, slap inflicted by law enforcement to persons under their control, particularly weighty. Paragraph 112, this is making the point that I made earlier, which is there had only been minor bodily injuries, no evidence of serious physical suffering, but nonetheless, this constitutes degrading treatment. For the avoidance of doubt, we are not saying there's a general rule, because that was rejected in Demikai, that any beating will always suffice. We are saying that factors such as, are you hit in the face, are you in police custody, or another form of custody of the state, and therefore particularly vulnerable, may lead to treatment being found to be degrading. Now, I want to quickly address a point that the respondent makes about Article 3 and materiality, and this is at paragraph 37 of the respondent's amended skeleton argument. The respondent suggests, well, there's a different threshold for past and future Article 3 harm. This isn't an Article 3 case, it's a Refugee Convention case. To the extent that we refer to Article 3 jurisprudence, it's for guidance about what can amount to persecution. And it's abundantly clear, for the purposes of the issues before this court, from cases such as Demikai, MI Pakistan, Y and Z, and also the terms of the 2006 regulations and now Section 31 of the NABA Act, these make abundantly clear that there's no different threshold of gravity for past and future persecution in the Refugee Convention. And I think what the respondent is groping for is 2 points that are axiomatic. One is, of course, it is more difficult evidentially to establish future harm, because you're not, the court won't be looking at a, for example, a logbook of incidents of violence in detention. And the other point to which the respondent may be adverting is that when assessing future serious harm for Article 3 purposes, conduct which may have a degrading intention in one country may not have the same intention in another. So the classic example is slopping out. So the fact that slopping out may be seen as degrading in Scotland does not mean it's degrading in every country in the world. That's Lord Brown's point in case of Wellington. But that doesn't apply to beatings. There is no case that suggests that beatings are somehow differently serious according to where they occur or when they occur. And I am very grateful to the court for its patience and for allowing me the additional time. For all those reasons, we do say that the first tier tribunal has materially erred in law, and that the upper tribunal should not have upheld its judgment.
Mr. Bielski, thank you very much indeed, and thank you also to Miss Irving for her contribution to those those submissions. Very well. Well, we'll sit at 2:05 to hear Mr. Tabori. Thank you. After you.